the matter of Kane and the Independent Adjudicator on another.
Yes, Mr. Grandison.
Thank you. I appear on behalf of the Secretary of State's Justice in this matter. My late friend, Mr. Bimler, represents the respondent. My Lord, after a few short points by way of introduction, I intend to structure my submissions in the following way. Firstly, deal with the underlying factual documents, which I really need to take you to some.
Sorry, could you
keep your voice?
Sorry. Apologies, my Lord. First, I intend to address the underlying factual documents in some detail. Second, move on to the legal framework governing disciplinary offences. And then thirdly, dealing with my submissions on the two grounds of appeal. But I want to deal firstly with some introductory matters. Firstly, by way of apologies, I only submitted a cross-reference version of my skeleton argument yesterday afternoon. Hopefully that has made its way to you.
Don't worry about that. But we had in the bundle your permission to appeal skeleton, and that is doing service.
Yes,
the main
that's correct. Yes,
that's
the
fine.
document I intend to rely upon. The second apology is in relation to the witness statement of Independent Adjudicator right. Rather bizarrely, it appears in the authorities bundle. That was oversight on my part when constructing the original bundle. So it's at 314. I didn't intend to take you to it because, of course, it's after the decision was taken. But just for your records, 314 of the authorities bundle.
Yes.
The next point I wish to deal with by way of introduction is just in case there's any argument as to this appeal since becoming academic. The reason for that, you may have had sight of a witness statement from Hans de Ladver in the supplementary bundle at SB 152. This deals in overview with amendments that were made to 53A of the prison rules in light of both this case and another case of O'Brien. So that deals with the ability of the independent adjudicator to refer the matter back to a governor, either because they don't think the offence is serious enough, or secondly, covering the case of O'Brien, in order to have the matter referred to the police. We submit, though, however, that notwithstanding this amendment to the prison rules, which came into effect in April of this year, the appeal is not rendered academic. Firstly, and I'll come to it in greater detail later on, it's still necessary for the governor to first determine the seriousness of the offence. Obviously, the complaint here is that the governor has not addressed their mind to the seriousness test. And that is still the matter under the new rules. The governor must first, in order to confer jurisdiction on the independent adjudicator, consider the seriousness test. Secondly, if it does happen to go before the independent adjudicator and the independent adjudicator thinks, well, I'm not satisfied this is serious enough, he or she then refers it back to the governor. The governor doesn't have an opportunity to improve upon the reasons given. So once it's referred back to the governor, they're stuck with it.
Can you help with this? I ought to know. Can a governor award any additional days at all?
No, that's correct, my lord. No, the maximum sentence they can impose is salary of confinement. That was in light of the European Court of Human Rights decision called Eze Connors, which is why the independent adjudicator system came about, because they needed independence in order to impose additional days, so governors can't. And furthermore, you can only impose additional days on determinate sentence prisoners, not those subject to IPPs or life sentences.
Oh, sorry. Say that again. So governors can't.
Governors cannot impose additional days
At all.
at all. And independent adjudicators can impose additional days up to a maximum of 42.
Yes.
But only where the offender is serving a determinate sentence of imprisonment, not where they're serving a life sentence on an IPP.
So what sanctions are there, if any, on a prisoner who is serving an indeterminate sentence?
Then they perhaps encourage, there's certainly a case like, I think it's in the bundle, a decision of Mr. Justice Collins dealing with referrals to the police. So that pretty much is the only proper sanction that can be imposed. So the court can, of course, impose additional sentences with the direction that the sentence commences at the end of the current term.
Yes.
So in
Yes.
essence, the new amendments to the regulations don't necessarily change the duty of the governor to first consider it. Secondly, once it's referred back to the governor's stuck with it. So if, for example, the reasons aren't considered sufficient enough, the governor cannot improve upon those reasons, and so somebody who's committed what is on the surface a very serious offence will not receive additional days because the governor's, use the phrase, but stuck with it, cannot refer it back to the IA.
Is the question of providing reasons any different under the new system than it was under the old?
No. If anything, the guidance is stricter. So the guidance in light of this.
But it's only guidance.
It's only guidance. That's
Right.
correct.
There's no mandatory requirement to provide reasons.
Not in the rules. No. So the rules aren't different in that regard. But the guidance now makes it clear you may not want to refer to the existence of a police referral or simply refer to the serious nature of the offence. And that, of course, was written in light of Mr. Mercer, Queen's Council's decision.
I think perhaps when you get to a convenient point in your submissions, it would be helpful just to look at the new rule and what's said about it. But you both refer to it as strengthening your case, but of course we are deciding the present case under the old rule.
No, of course. It was just simply, apologies, I'm going on about it, but this was just by way of introduction to simply show this case isn't academic. And the third reason, perhaps more important, is that in the statement of Hansel Adler, we stated that it's not academic because the only way to enforce the 18 additional days in this case is for the Court of Appeal to allow the case. It's since emerged that can no longer take place. The reason being is that he was released from his determinate sentence in January of this year.
Okay.
And whilst he was recalled the following month, the rules are that you cannot impose the days after somebody's been recalled. So if he commits further offence, of course, that may change the position. But yes, he essentially in this case escapes from having to serve the 18 additional days. But of course, it may be relevant for parole board considerations when, for example, they're considering release following his recall and licence. They may take into account his behaviour in custody. So it'd be relevant for those purposes, but it has to be clear now that he cannot serve his 18 additional days, regardless of his court's decision. So, with those preliminary points in mind, can I turn very briefly to the introduction? Of course, this is a case challenging the decision of Hugh Mercer, Queen's Counsel, sitting as a Deputy High Court Judge.
Forgive me for interrupting, but could you just go back to the point you made a moment ago? He was released on licence.
So he was released on licence, yes.
So let's suppose there'd be no argument about the 18 days and they had been added.
Yes.
What would the significance of those added days have
It
been?
would have pushed back his release on licence date,
Right.
so it affects the early release date.
So they're taken into account in calculating the release on licence date.
That's correct.
But as it happens, at the time that he was released on licence, the deputy's decision meant that they weren't taken into
That's
account.
correct.
Understand.
Yes, my lord. So yes, he does get off.
Yeah.
In this case.
I don't think Mr. Bimler suggests that we can't hear this appeal because it's become academic.
No, these are very recent developments. I only found out about the sentence yesterday, and so I just wanted to address it as part of the duty of candour.
Of course.
So as not to waste anybody's time, just in case Mr. Bimler were to point out that this was academic. My lord, of course, this has challenged the decision of Hugh Mercer, Queen's Counsel, as it was, allowing a claim for judicial review and quashing the order of Independent Adjudicator right. Independent Adjudicator right was a district judge sitting in the role of an Independent Adjudicator. Permission was granted by Lord Justice Singh on 2 grounds. Those were, 1, wrong to have concluded that Independent Adjudicator right lacked jurisdiction, and secondly, if Independent Adjudicator right had been wrong, Mr. Mercer, Queen's Counsel, failed to take into account provisions under section 31(2)(a) of the Senior Courts Act. So essentially, highly likely the outcome wouldn't have been any different. The factual background is relatively convoluted in this case, but I would tend to take you to it in some detail if I might. You should have 3 bundles before you: the core bundle, so CB, supplementary bundle SB, and authorities bundle AB. So the initial part of the factual background, I think, is all confined to the core bundle. Can I turn your attention to CB 163, please?
Ms. Granson, I'm grateful for the electronic bundles,
Ah,
but as it's the GLB, could they have the same numbering?
yes.
It's
It
an endemic problem, but I've got 3 sets of bundles which all have different differences.
Yes, I apologise.
And if anybody ought to be getting this right, it's
This is
your plant.
Yes,
But thank you.
I apologise.
No, just a point in passing.
Thank you. I think for the core bundle, it's 2 pages difference, if that's of any
Yes,
assistance.
I've
So
got
I don't have the electronic bundle, I have the hard copy, so it's 163, so I think that makes it 165.
No, once I've mentioned it once, you don't have to think about it again.
Thank you. I'm very grateful. So this is the charge sheet written up by Governor Wood, who was the complainant in this matter. This is the charge sheet that would have been before, so it's handed to the prisoner straight after the charge is drawn up. It's then before the governor when they're referring the matter to the police, before the second governor when they're referring the matter to the independent adjudicator, and then before the independent adjudicator when they're dealing with sort of preliminary issues. So this is essentially, in criminal proceedings, the statement case.
Has the deputy judge correctly summarised the facts at paragraph 3 of the judgment? That doesn't.
I certainly hadn't noted that they had incorrectly done so. So yes, I mean it's a relatively short, swift summary of the charges here. Can I ask you very briefly to read it, because of course it's the forefront of our case that this is so obvious a serious case and passes a serious test.
Yes.
That it should have been evident to anybody considering the matter, notwithstanding the hoops that needed to be jumped through. So just consider that one box, details of alleged offence. Thank you.
Yes.
So anybody considering it would be able to discern certain facts from it. Firstly, that this is an incident that occurred in a Category A prison. HMP Whitemore holds Category A prisoners. Secondly, it arose from a governor essentially telling a prisoner that he couldn't do something in relation to a letter. A letter couldn't go out in its current format. Thirdly, that he used vile and insulting language to a governor, and a governor, I accept, isn't the senior governor of the prison, but it's certainly a senior management position within a prison. So it's a governor-grade position. He then proceeded to smash prison property by the applications box, and then used a piece of that debris to assault the governor, and on the basis of the independent adjudicator's findings, intended to hit her. And thereafter continued his tirade while standing on the netting, certainly putting his health and safety in jeopardy, if not others. The matter was then swiftly before an adjudication governor. That reference is CB 165. So this is a governor who's received training in undertaking adjudication. And you'll note midway down the box, section 2, it sets out referral to the police, and it gives you the test and also the relevant parts of the PSI that one can refer to if one is in any doubt as to the test. And of course, it's box ticks referred, and then just below that, the next paragraph starting, if it is not referred to the police, or the police confirm that no prosecution is to take place, consider whether the charge is serious enough to refer to an independent adjudicator, and then gives the annex paragraphs. So again, sets out the test, where one to be in any doubt as to what requires referral to the independent adjudicator. They're then to give, as you'll see from section 2, reasons. Section 6. Section 6 is at CB 171. Now, the first sentence appears to relate to the charge, sorry, the referral of the charge to the police. That was filled in by Governor number 1. And the second one refers to the referral to the Independent Adjudicator Government number 2. First one states, due to the nature of this charge, it is to be referred to the police. And that was dated 8th of the 6th, 2020. And we know, although it doesn't appear in this hearing record, that the police returned it, I think, some 2 days later. And so it went before the second governor. And the second governor was noted, Mr. Kane has asked for legal advice due to the short time span between first and second hearings. I've agreed to 2 days. I can't read that word, I'm afraid. Legal, thank you. I'm very grateful. Legal. Due to the nature and the police returning the charge, I will send to the IA. So, brief I accept, but reasons nonetheless.
Those 2 paragraphs read as though they were written on different days.
That's correct.
Yeah.
Yes, that's what I'm saying. So the first one is dated the 8th of the 6th, and then the second one would be by the second governor, I think on the 10th of the 6th. So the matter is then formally referred to the Independent Adjudicator. The first hearing before them is at page 175. So this is the Independent Adjudicator's hearing record, so it differs from the preceding record. They have their own forms. And it's before Deputy District Judge Day, sitting as an Independent Adjudicator. They hear it on the 26th of June 2020. And you'll note that they must answer a series of yes-no questions.
So sorry, which page?
Sorry, this is 175 it starts. So it's was charge referred to the police, has been laid as soon as possible, was it inquired into the governor within certain times. The important questions of this case are at 176, and they are F and G. So is the Independent Adjudicator, I just refer to him as IA now, satisfied that the governor gave proper consideration to whether the charge is so serious that added days should be awarded if the prisoner is guilty, i.e. the offence poses a very serious risk to order and control the establishment or safety of those within it. And IA Day has said yes. I accept there's no legal argument at this point, but they evidently formed the opinion on the papers before them that the governor had considered the seriousness test. IA Day then adjourns the case once more to allow for legal assistance. It's a brief handwritten reference at 178.
Yes, can you decipher that? Adjourned to...
Adjourned due to non-sitting of legal something rep CCTV and RO to be available. So I think RO
next sitting.
Apologies.
Could it be next sitting?
I think it might well be, yes. Sorry, I should spend more time trying to decide.
It's all right. Yes. Adjourn to next sitting.
Yes.
For legal advice.
Legal advice. Thank you. Go for time in front.
And representation. And rep.
Yes. Thank you.
This series of documents you've shown us, each is headed record of a hearing. But was any of them, in fact, a hearing in the sense that people come face to face, or was it what we would think of as consideration on the papers?
I believe, my learned firm, correct me if I'm wrong, because those who instructed were present, I believe it is actually a hearing.
Hearing,
yes.
Right.
Albeit with all the informality that occurs in the prison environment, given this is a lengthy list, but I don't think it's dealt with on the papers. I think it was actually a hearing.
Could we go back to 176 and to the note under letter F?
Yes. See associated charges.
It's NB, the corrosive effect. Do you have that under letter F on page 176?
Yes.
In italic.
Oh, yes, of course. NB, the corrosive effect
Yes.
on orders.
I mean, so for example, this had taken a different course. This particular prisoner had 28 findings of guilt. No idea what they were about. No relevance.
We know there weren't assaults.
Exactly, but no relevance to this appeal. But let's take not necessarily him, but another person on the estate.
Yes.
who had a long record of breaching the prison rules. And there was another event which was of itself not what you claim here, which is an obviousness
Yes.
one, but it was simply the last straw,
Yes.
for example, of repeated infractions. Then in those circumstances it would be expected that the person referring to the IA would say, although in itself not, this is part of a sequence.
Yes. Yes.
So that might be something that a reason would be particularly appropriate for.
That's good.
Something that of itself might not expect from the PSI to amount to a referral.
That's correct. Yes, you'd expect them to put it, if it's not obvious, then you would expect the reasons to be more detailed. And of course, yes, I know my lady, they just dealt with a case called O'Brien, which was possession of mobile telephones. And whilst I think the independent adjudicator didn't consider it serious enough to refer to police when it was one offence, she had a sort of what was referred to as a policy referring when it was a second or third sequential offence to the police. And so, yes, the prison environment will seek to punish those who are repeat offenders, essentially. And so, of course, the seriousness may be enhanced the more times one commits offences in this time. But yes, you'd expect, if it wasn't obvious to the reader, further and better reasons to be provided for the referral. So we know that IA Day did adjourn it. It was then next before IA Wright on the 17th of July. This is page 180. But again, has to be adjourned on this occasion because whilst the solicitor was instructed, they hadn't managed to dial into the hearing. So the reasons set out in 183. I think also the reporting officer wasn't available. So it had to be adjourned by IA Wright through to the substantive hearing, which took place on the 31st of July, and that starts at page 188. So you have the same form as before, albeit this one is completed by IA Wright as opposed to IA Day. So it's not a continuation of their form, it's a separate form, albeit the same template. And you'll note from page 189, boxes F and G, that IA Wright is satisfied that the governor gave proper consideration to the seriousness test, and that the IA themselves are satisfied that the prisoner is eligible for additional days. Now, as we're all aware, a preliminary point was taken by Mr. Conningham, representing Respondent in that matter, and that is referred to at page 191. So if I ask you to read paragraphs 2 and 3 of the narrative record at 191, please.
Yes.
Thank you. Having dismissed the challenge, you then have a summary of the evidence. I won't take you through that at this stage. And then on 193, the findings, the only relevant one essentially is, you'll see a third of the way down the page, the heading findings. And then the third paragraph of that, I did not accept Mr. Kane's suggestion that he did not appreciate the risk that it could have hit her. In fact, I'm sure he intended to hit her with the wood. And so the finding, in fact, made by judicial office holder that upon throwing the item wood, he did intend to hit the governor. Found both matters prove, sorry, I should have said at the outset that once the procedural finding had gone against the respondent, he pleaded or accepted guilt in relation to two of the offences, the criminal damage and the using offensive and insulting words of behaviour. And the other matters were found proved against him. And then you have the sentence at 193 at the bottom. So sentence of 18 days concurrent on the matters for which he contested, and then 12 for the matters to which he accepted guilt. And due to that, to run concurrently, it's a total of 18 days. And there concluded the hearing. You then have a number of pages. I know this matter was assigned to this court relatively late, so I don't expect you to have read everything. I don't think there's any disagreement between my learned friend and I that the remainder of the hearing records are irrelevant for your purposes.
Yeah.
They're duplications and they deal
Yes.
with the other charges. There's nothing, I refer to my learned friend, there's nothing contained in those that will affect this case in any way, shape or form. The next relevant document is right at the end of the court bundle, page 296. This is an application made by the respondent to the senior district judge sitting at Westminster Magistrates Court for a review of the sentence. This he was entitled to do. He's not entitled to challenge the finding of guilt. He'd have to go by way of judicial review for that. He is entitled to seek a review of the sentence. So the application is 296, 297, and then you have the decision of District Judge Guzzi at 298. So he was the judge assigned to the case by the senior district judge. And the relevant part is at 299, the final substantive paragraph starting, these are a combination of serious disciplinary offences, where you deliberately threw a piece of wood, weaponised the Governor Wood, deliberately jumped onto the net, and considering the awards you could have received for these charges, the total award of 18 additional days cannot be described as manifestly excessive.
Yes, thank you.
Thank you. So that deals hopefully with the factual background in as much detail as is necessary. I then turn to the legal background. I know my lady will be familiar with this, having given the leading judgment to O'Brien, but I will take you through it in a short amount of detail. So the prison rules are rules that are enacted by way of statutory instrument pursuant to section 47(1) of the Prison Act. And the relevant provision is Rule 51, which creates a set of disciplinary offences. So this is contained in the supplementary bundle, SB 129. Now I have the disadvantage of using a hard copy that the numbers don't appear on the right-hand side of the page. So apologies if there are any errors on my part. So 129, offences against discipline.
Yes.
And note that it's offences against discipline, not criminal offences or any such wording. The important one here, and the one that warranted referral both to the police and the independent adjudicator, is 51(1), commits any assault. And then all the others are set out thereafter. But the only relevant one is committing assault. All the others were sent up as associated charges. The rule governing referral to the independent adjudicator at 53A, so just over the page at 130. And this was the rule in force at the time, not obviously the recent amendments. So determination of the mode of inquiry. Before inquiring into the charge, the Governor shall determine 1. Whether the charge is so serious that additional days should be awarded for the offence if the prisoner is found guilty, or 2. Whether it's necessary or expedient for some other reason for the charge to be inquired into by the adjudicator. The sub, so Roman numeral 2, refers to life sentence prisoners. So there can be circumstances, for example, where they want to mark the seriousness of the offence by having an independent adjudicator here, even though they cannot impose additional days. So that was a relatively recent amendment to the rules, but there's no suggestion that it applies here. It's simply just based on the seriousness test, i.e. the additional days one. So it's for the Governor to determine if an offender in agreement on that, whether the charge is so serious that additional days should be awarded. Where the Governor answers yes to one of those questions, he shall refer it to the independent adjudicator subpart. That's Rule 53A2. And all associated charges go along with it. That's Rule subsection 2, Roman numerals 2. If the government decides it's not so serious, then they're obliged to consider the matter themselves, although they can continue with the hearing and then at some stage during the hearing prior to sentence decide that in fact it is so serious, and at that stage refer to the independent adjudicator. So they can hear all the substantive evidence, decide their sentencing powers are insufficient, and refer to the independent adjudicator. And as I stated at the outset, the main power that the independent adjudicator has that the governor doesn't is the power to impose additional days, and that, for your reference, is Rule 55A 1B. And the only other relevant rule is 55B on SB 132, and that gives the senior magistrate the power to review the punishment but not find the guilt. So that was the challenge mechanism that we just saw at the end of the core bundle. So these are the rules in force at the time.
And the 55B1 seems very oddly worded. Nothing turns on it, but
No.
it seems nonsensical to me. Well, perhaps we don't need to look into it.
I must admit I hadn't.
There is only one
Yes,
Chief Magistrate.
that's correct.
Anyway.
Yes. Yes, I'm unsure as to. I must admit I've never considered in detail that provision. So these are the rules. You then have the policy document. One in force at the time was PSI 05/2018. That starts towards the beginning of the supplementary bundle at page 13. A few preliminary references just to make before I deal with the substance of the guidance. Can I turn your attention to the bottom of page 14 and the reference in bold, note all mandatory actions throughout this instruction or in italics must be strictly adhered to. It differentiates between italicized wording and non-italicized as to whether or not it's mandatory. And then can I turn your attention to SB 18, paragraph 1.14. And this reaffirms that IAs attend prison to exercise their powers independent of the prison service. They are bound by the Prison and Young Offender Institute rules. They are not legally bound to comply with this PSI. So I think you may have noted when reading IA Wright's decision, she said she wasn't bound by the PSI. That's correct. There's obviously hope that they will adhere to it, but they're not bound by it.
What is the legal status of a PSI such as this? It says it's issued by HMPPS Agency Board. Is
Yes.
that on behalf of the Secretary of State?
That's correct, yes. Yes, so it would bind governors, and the principles arising in them, I would have thought, would apply. If a mandatory instruction is given there, then good reason would need to be shown for a governor.
And did you show us the source of the Secretary of State's power? Something in the Prison Act?
To make the rules,
Yes.
it's I don't have the act before me, but it's 47 subsection 1,
Right.
and they're dealt with by way of negative procedure.
Yes.
And PSI is an acronym for Prison Service
Instruction.
Instruction.
That's correct. So moving on to the substantive parts of this bond, they're contained in Annex A. So if I can take you to SB 41, please. And it's paragraph 2.23. Can I ask you to read the first 7 lines up to police referral, please?
Yes.
So it's reserved situations either where the victim requests it or the internal disciplinary process are deemed insufficient to deal with the offence. There's no indication that the victim sought a referral to the police in this case. Can you then turn the page, please? Page 42, 2.28. I can ask you to read that, please. So it deals with those who are serving determinate sentences. 2.29 is not relevant. 2.30 is the associated charges, which I've taken you through already. And then the important part here is 2.31. Note that the majority isn't in italics. The adjudicator should state their reasons for referral to the IA in form IA1 under additional comments as quoting the seriousness of the offence alone may not be sufficient in all cases. And then care should be taken not to compromise their independence. Staff must not disclose individual cases with the IA. 2.32 deals with the test for seriousness. So of course you have the test contained at 53A1. Whether or not it warrants additional days. In determining whether or not it's serious, you take into account the effect on the good order and discipline in the prison. So the test of seriousness is whether the offence poses a very serious risk to order and control of the establishment or the safety of those within it. Accepts that each case will be assessed on its own merits. Serious assault should always be referred. And then gives some guidance at the bottom. The relevant one here is bullet point 3, the victim's role within the establishment, e.g. staff, the vulnerability and the location of the incident will also be factored. And then finally within this document, 2.33 on page 43, and this is the independent adjudicator's power at the time to dismiss a matter where referral to them is unlawful. And it gives an example. And so prior to the amendments, they couldn't remit the matter back. They simply had to dismiss it. So you have the test in mind of seriousness, but the other factor, of course, is whether or not it warrants additional days. You have, right at the beginning of the supplementary bundle, the sentencing guidelines for independent adjudicators. Can I turn your attention to page 3, please? And it's the first box, so Rule 51, paragraph 1. We submit that this is committing any assault upon staff, weapon used, starting point will be 38 days, with a range of 35 to 42 hours.
So sorry, which page?
Sorry, this is page 3 of the supplementary bundle. This is the independent adjudicator's sentencing guidelines. So committing an assault upon staff, weapon used, starting point 38 days, with a range of 35 to 42 days. And just out of interest, the point I'll be making slightly later on is the special nature of disciplinary proceedings within a prison as opposed to their criminal counterparts. Can I turn your attention to page 5? So this is Rule 5120, using threatening, abusive, or insulting words or behaviours. This is the matter to which he pleaded guilty, and that has a starting point of 14 days with a range of 5 to 30. So this is towards the bottom of page 5.
So it might be thought applying the guidelines, the sentence was relatively lenient,
Yes, yes, Miss.
well below the starting point for the
Yes, sir.
assault.
Yes,
And these are the Chief Magistrate's
That's correct.
guidelines, not
no, not this
Administrative
individual judge,
no,
chief
so
magistrate. Sorry, I should
Yeah.
refer to them as the independent adjudicators ones. Yes, the chief magistrates. And so clearly, an offence which isn't imprisonable were it to be committed in mainstream society, that is Section 5 of the Public Orders Act, is viewed incredibly seriously in the prison environment. And then the final sort of policy document, so to speak, that I wish to turn to is the Crime in Prison Referral Agreement. So this is agreement between the CPS, the police, and the prison as to which offences should be referred to the police. And this is relevant for the argument as to whether or not the threshold is higher or lower in respect to referrals to the police as opposed to referrals to the independent adjudicator. This is starting at SB 112. 7th May 2019, so in full at the time. It then deals with mandatory cases that must always be referred. That's SB 119. That's Annex A. This case doesn't fall within that, because we accept that there were no injuries. But midway down the page, you'll see the reference to assaults against a member of staff, except where there's little or no injury, see Annex B. So we turn to Annex B, headed Staff Assaults. Paragraph 1, other than those less serious assaults where there was little or no injury, which are more appropriately dealt with by adjudication, all assaults on staff will be referred to the police for investigation and consideration for prosecution. So I accept here there's little or no injury, so one could interpret paragraph 1 as being an issue. You'll note at paragraph 4, there may be factors which would indicate a referral to the police, and each incident should be considered on a case-by-case basis, including considering the perpetrator's offending history. This may include, but is not limited to, where there is a clear intent to cause more serious injury than that sustained. You'll note from, obviously, the charge sheet that this gentleman threw a pint of wood at a governor, and only because the governor ducked did it not hit her. So clearly, clear intent to cause more serious injury, unfortunately, was caused. So that summarises the prison rules and the policy documents, hopefully relatively briefly. Where the time, I move on very quickly to a few principles that one can derive from the authorities. I'm not going to take you through all of them, please don't worry about that, but the main ones for this purpose. The first is Wilson. That starts at the authorities bundle, page 142. Judgment of the Divisional Court with Lord Justice Burnett and Justice Hughes.
If you've referred to any of these authorities in your skeleton, can you just take us to that?
To the skeleton.
Taking this as an example, if all you want from Wilson is paragraph 33, then we can take it from the skeleton.
I'm very grateful.
If you need context, then take us to the report.
Of course. Then I won't take you to 33. That's obviously included. I'm grateful for the indication, my lord. But can I just ask you to read 37 as well? It's a very brief paragraph that deals with. So it's page 150.
I'm so sorry.
Sorry.
Start again.
Sorry, page 150 of this bundle. So the only other paragraph I wish to refer to was paragraph 37. So paragraph 33, my lord observed, is in the skeleton argument. Paragraph 37, I don't believe is.
No, it's not. It's not that I know paragraph 33 by heart. It's just.
No, of course.
It's just. It saves note taking if you've put it all in the skeleton. So, page 150.
150. Paragraph 37. And that stresses the importance about matters being resolved quickly in the interest of order, discipline, fairness, with some informality. And 33, as I said, of course, it's summarised in scales. The point derived from that is that 51, so Rule 51, creates disciplinary offences, not criminal offences. So the focus is always on the impact of that action in prison. So of course, certain matters under the rules aren't even criminal offences, so drinking alcohol, for example. But of course, they clearly pose a risk to good order and discipline in a prison, and so are punished heavily in that environment. It's similar to the sort of military punishments, I think. That's the closest analogy I can find. You have special considerations for disciplinary matters in military life that are treated far more seriously than they are in civilian. The next case, again, as I stated, familiar to my lady, is O'Brien. That starts at AB 187. I don't think I did include this quote in my scales and argument. So AB 187 is the start of the case. But the question before the court is whether or not the independent adjudicator had a power to refer a matter to the police themselves. The answer was no, which, as I said at the outset, prompted the change in the rules, so that now can be done. The principles I wish to draw your attention to are AB 200, that's paragraph 68, please. So my lady sets out the legislative context, which is the rules, and 6 points in particular. Can I draw your attention? We submit the more important ones are 3, 4, and 6. So 3 is expediency. 4 is has a bespoke list of disciplinary offences as opposed to criminal ones. And then 6, the knowledge that the governor has over the regime that they preside in. Finally, the governor has the big picture about what happens in the prison, the IA does not.
Under the rules, there's reference to the governor.
Yes, Madam.
And the interpretation section says the governor includes anyone who's for the time being in charge of the prison. In fact, as I understand it, the word governor is used in 2 senses in prisons, that it's not only the most senior person, but anybody else of governor rank.
That's correct.
And here it seems to mean anybody else of governor rank. Do we know, does it matter who is to deal with a case such as this is determined?
I know that, sorry, I'm trying to do this from recollection. I know that they've had to have undergone training. I can, when my friend's on this video, I can try and find the reference to it because it will be in the PSI. I know they have to have undergone training, and I'm supposing that the head governor delegated them as one of a number of small number of governors suitable to hear these hearings.
Well, it couldn't be the complainant,
no.
In effect, for obvious reasons.
No.
So it's one of the others selected,
That's correct.
probably by the head one or
That's correct.
governing governor. Yes. Okay.
Yes, that's
Thank you.
So that deals with all the authorities I wish to take the court to at this stage.
Yes.
Can I then move on? We're getting close to the submissions, I promise you. The Deputy Judge's judgment starts at page 65 of the core bundle. I'm just reviewing paragraph 3 that my my lord drew my attention to at the beginning, no, there's no dispute as to that. That's on that facts. You'll note paragraph 15. Final sentence, in my judgment, the view which matters in relation to the seriousness of the charge is that of the governor making the fail that is agreed between both parties. You then have the deputy judge analyse the two reasons given by independent adjudicator White. The first one is the reference to new regulations due to COVID-19. The deputy judge finds correctly that it must have been a mistake. There were no new regulations that impacted upon this particular case. And so the deputy judge found that IA Wright took into account an irrelevant consideration. So that's paragraph 18.9.5. He then went on to say, notwithstanding that, he didn't think that the guidance was relevant. There was no indication either that independent adjudicator White had referred to it, or more importantly, the governor who referred the matter to her. He took into account IA Wright's statement, which, as I say, is at 314 of the authorities bundle, and didn't really think the statement took matters any further, and so in essence found that first reason given by IA Wright was irrelevant. And then more importantly for the purposes of the challenge in these proceedings is the second reason. The Deputy Judge deals with that at paragraph 26. DJ Wright's second consideration is as follows. Second, although the governor does not explicitly say so, he felt the matter was serious enough for referral to the police. And obviously you'll wish to read this in greater detail at your leisure, but can I ask you to take focus particularly on paragraph 30. Which deals with the assertion that reference to nature may not take matters any further because assaults can be many and varied. And then the Deputy Judge's conclusion is at 31. So in conclusion, the reasons given by DJ Wright for considering the governor to have properly considered the threshold for referral failed to reveal any consideration of the so serious threshold by the second governor. Accordingly, in my judgment, DJ Wright lacked the power to proceed the adjudication and should have dismissed it. We obviously appealed that, and you have the order on the following page 75, Lord Justice Singh granting permission. I now come on to the submissions. And my learned friend correctly pointed out my skeleton argument in error referred to 5 factors and only listed 4. And it's a trap that many an advocate falls into. There are only 4. I apologise for that.
Right.
I only intend to detain you for 4 submissions on ground 1.
Yes.
So the first one is that we submit it was pellucidly clear to the independent adjudicator what the referring governor had meant when referring to the nature of the charge. The phrase due to the nature of the police returning the charge must be seen within the context in which it was made. In relation to this first point, I make 4 sub-points. Firstly, the context is the author. This is an assault of a governor with a weapon. Nature of such conduct, clearly we submit, is going to pose a very serious risk to the good order and discipline in a high security prison. And the governor who had referred the matter to the independent adjudicator would clearly have been aware of that. I referred to my lady's reference in O'Brien, the final point, that the governor is the one with the overview picture, the big picture of the prison environment. So the context is the author. The second factor here is the audience. So this is a reason given by the governor to an independent adjudicator, so somebody who has received specialist training, sits as a judicial office holder, specifically to come into prison to deal with disciplinary offences. The reason we submit, given as section 6 of the referral form, to somebody who's cognizant of prison discipline, again, would have been obvious. This isn't a case where it involves providing reasons to a layperson. It's essentially two knowing parties giving shorthand, writing shorthand. And I just noticed I fall into exactly the same trap again. I said there were 4 factors, there are in fact 3 factors under this first point. The third one is the nature of the decision. The governor's making an administrative decision. I fully accept that were they dealing with findings of guilt or something substantive such as that, then reasons would need to be detailed. This, on the other hand, is an administrative referral to an independent adjudicator by a governor who is not legally trained, who is not at the time asked to justify their decision by a party before them, or not ordinarily, because of course they weren't represented at this stage, in a system which prizes expediency and swift justice. So rather than beautifully eloquent judgments that this court may deal with, this is a system that prizes speed over almost anything else. I accept that paragraph 2.31 of the PSI tells governors that they should provide reasons, because creating the seriousness of the offence may not be sufficient. That has been recognised in many a case. Sometimes the reasons are so obvious that no lengthy or detailed consideration is needed. Whilst I referred to 2 cases in the background to law, can I just take you very briefly to the case of Vasey? It's Authority Bundle 180, paragraph 35. So this is a Court of Appeal judgment dealing with a criminal appeals, multiple criminal appeals, in order to give guidance as to whether or not the offence of potting, so throwing urine or faeces over prison floors, falls within the noxious substances offence, and also thereafter provides guidance as to appropriate sentence. But the relevant paragraph here is 35, because Mr. Wall, who represented Mr. Vasey, had challenged the referral to the police and the lack of reasons given. And the judgment of the court is that essentially, 4 lines down, whatever deficiencies there might have been in the contemporaneous paperwork, Vasey has shown no basis for challenging the later evidence of the governor as to the reasons why internal disciplinary sanctions would not meet the seriousness of the case. Those reasons are in reality obvious. No lengthy or detailed consideration was needed to reach the conclusion incidents should be referred to the CPS. So I accept this as a referral to the police rather than referral to the independent adjudicator. But the same reasoning applies. It's focusing on the reasons given by a governor when referring to one of those 2 bodies.
Yes, the reference to later evidence of the governor might be a bit controversial.
Yes.
Speaking for myself, if you're right about the obviousness point, then that's a good point,
Yes.
and one doesn't need later reasons
Correct.
from the governor. If you're not right about the obvious point, then you might be in difficulty, and you couldn't be rescued by the obviously what the governor wrote at the time is admissible. What she says later in a witness statement.
Yes, which is why I've not drawn your attention to it, save for pointing its existence.
Yes.
I'm not taking you to it at all.
Yeah.
I don't think I need to, quite frankly. I wholly agree with you, Michael.
Thank you.
Yes, so 35, that in certain cases, dealing specifically with this context of referrals made by governors, albeit to the police as opposed to independent adjudicator, sometimes recognition that reasons need not be gone into in great detail. They are obvious.
So this is appreciate you're in the middle of a list which you haven't yet finished, but
Of course.
This is referable to the Deputy Judge's paragraph 13, which he's saying that the must be apparent to the adjudicator that the governor has applied his mind to the so serious threshold.
Yes.
Expect to see brief reasoning capable of being interpreted as addressing the threshold stated on the face of the decision, mandatory nature of the rule, the use of the word determined,
Right.
the governor has determined.
Yes, that's right.
So all of that you say is just wrong.
Well, no, one has to determine. I fully accept that.
No, but I mean, a determination does not mean you say a mandatory series of reasons.
I think that given the seriousness or the obvious seriousness of the offence, the reasons could be as brief as they were. So simply referring to the nature of the offence, the fact it's being referred back to the police, that from the governor of the prison, who has that charge sheet form, to an independent adjudicator, who has that charge sheet form, it would have been elusively clear. So yes, the reasons in those circumstances need not be detailed. They don't have to. And remember, the adjudicating governor will deal with many, many cases at the same time. If, for example, they have to address their mind for every single offence, so all four of those offences, to the criteria that I've spent a long time taking you to, it could slow down the system a great deal more. I'm aware the guidance encourages people to give reasons, but certain cases we submit, reasons can be as brief as they are in this matter. So that deals with point 1 and following the structure of the skeleton argument. So I'm just developing upon that. So there were 4 points, everything referred to as 4 points. That's point 1 dealt with. The second point is the deputy judge, Hugh Mercer, failed to appreciate the very limited scope of the adjudicator's power to review. In this case, he or she could only review on the basis of unlawfulness. We submit that the test under
to review the referral.
the referral, that's correct.
Yes.
Yes. So it's just simply whether or not it was lawful or unlawful, because that's, of course, what gave them jurisdiction. We submit that the test under 53A1 is remarkably simple. Firstly, they ask themselves whether or not it poses a very serious risk to order and control of the establishment. The reasons I keep on harping on about, yes, assaulting a prison governor in front of colleagues clearly does. Will it warrant further days? I've taken you to the Chief Magistrate guidance. It's one of the more serious offences within that disciplinary guidelines, within those disciplinary guidelines. And is he eligible for additional days? Yes, he's in a determinate sentence prison, I think serving 40 months. So this isn't a complex test that sometimes Crown Court judges have to go through for, say, admitting bad character evidence. It is simply, does this pose a very serious risk to good order and discipline, and will it warrant further days?
If we were to assume that the facts in this case, contrary to your submission, were sort of marginal for referral, that would be one thing. But as I understand it, very, very serious things can, in theory, be referred to an adjudicator, an independent adjudicator.
Yes.
For example, because there aren't to be any police actions.
Yes.
So something that was beyond any power of argument as being very serious. Let's suppose it had struck and injured the governor,
Yes.
a piece of wood in this case, and that it then became beyond argument that this was so serious. But the same referral had been made.
Mm-hmm.
You might say that a flaw in the reasoning of the deputy judge is demonstrated by the absurdity
Yes. Yes, I think
of that outcome. It happens that we're in what might be described as a mid-range here, but one could imagine a situation in which serious injury had occurred.
Correct.
There wasn't, for some reason, to be immediate police action, and yet the JR would succeed.
Yes.
by that line of reasoning.
Exactly. I think you put it far better than I have. I think the natural follow-on process of the deputy judge's reasoning is it does lead to absurdity. You're having to justify the absolute obvious each and every occasion, every time you refer. I'm afraid I don't have evidence before you, but certainly some of the authorities refer to between 7,000 and 9,000 cases are referred to independent adjudicators a year. These figures are dated. I'm not relying on them as evidence, but they're certainly referred to in some of the authorities before you.
The rule 53A doesn't, on its face, contain constraints, but the 2.33 of Annex A, on which Mr. Bindler relies, unsurprisingly, says an unlawful referral would be one in which the PSI or prison rules have not been correctly followed, i.e. the case should not have been referred in the first place if the guidelines in the PSI were followed correctly. Is the Secretary of State standing by that statement?
The difficulty is that it's in the policy. That's my problem, is that it does refer to that. I think my learned friend would rely on the sort of general rule that policy should be complied with unless good reason shown otherwise, not doing so.
But otherwise, why should it be unlawful as opposed to annoying or a not very good use of resources to refer a trivial case?
Yes. But the difficulty is that those are the reasons that were argued before Hugh Mercer, Queen's Counsel, as Deputy Judge. That's the position I'm afraid I'm confronting. But as my Lord correctly pointed out, there's nothing within the prison rules that refer to the mandatory need to give reasons, detailed reasons or otherwise. It's just simply determined.
And has paragraph 2.33, has that sentence, the last two sentences of 2.33, remain unaltered post-amendment?
I need to double check. I know that the majority of 2.33 has changed considerably.
Because of referrals.
Exactly, because of referrals. And warning that references to so serious that the police have returned it, sort of remitted it back, may not be sufficient. So clearly it focuses on the reasoning provided by Hugh Mercer, Queen's Counsel, as the Deputy Judge, and seeks to address that so that others don't fall into the same trap. So just rounding off point 2, obviously set out how straightforward the test is, whether or not it poses a very serious risk. Point 1, this is from a governor of a high security prison. Will it warrant further days of taking you to the Chief Magistrate's guidance? And is he eligible for them? Yes, that was accepted. He's a determinate sentence prisoner. The factors that the Deputy Judge set out in paragraph 30, which I ask you to take into consideration when considering your judgment, we submit are more relevant to mitigation of sentence, not whether or not the referral was lawful. So the judge refers to COVID restrictions and previous offending and the like. We submit that when the judge is given a very small ambit to consider or review the governor's referral, they should be focusing just on whether or not it's lawful or not looking at what the likely sentence is in this particular case, when one takes into account mitigating circumstances.
Well, what do you say distinguishes a lawful referral from an unlawful referral?
I think, for example, if they'd just left the blocks blank, so they'd not considered, there would be no indication whatsoever they considered the seriousness to us. So no reasons whatsoever being provided. Box 6 and the papers have just found their way to the independent adjudicator's desk with no referral paperwork, that would be unlawful. By simply not going into the level of detail that the deputy judge required, we submit isn't unlawful where it's so obvious to all and sundry as to what the governor was referring to. Two more points, my lord. Point 3. We submit the
Sorry,
deputy...
just a minute.
Sorry, of course. Do you mind if I just quickly get some more water before I run out?
Please do, yes.
Thank you. Thank you, my lord. Point 3. We submit that the deputy judge erred by viewing the assault criminal counterpart rather than viewing it through the prism of disciplinary offences. The deputy judge stated that assaults are many and various. Now, I accept that in civil society, that were the same actions to be committed by a first-time offender to another individual in society, they're unlikely, in all cases, to have led to custody. But when you're committing the same conduct against a governor who's one of the figure points of authority in a high security prison, as they would be, say, a general in the armed forces, the factual matrix changes. Such conduct must be viewed as a disciplinary offence, not as its straightforward criminal counterpart. That conduct clearly poses serious risk to good order and discipline at HMP1. And finally, point 4, we submit the deputy judge failed to appreciate the relevance that the matter had been referred to the police. We don't accept, I know a friend's contention, that referral to the police is a lower test, a lesser test, than that warranted to referral to the independent adjudicator. Can I take you very briefly back to paragraph 2.23 of the guidance? So this is referrals to the police. It's SB 41. And it makes it clear that unless the victim requires the matter in the first place, and I say there's no evidence of that here, the guidance is that it should be referred to the police when it's determined that the relevant internal disciplinary processes are insufficient to deal with the offence. So the governor's clearly taken the view that were this individual to be found guilty, the 42 days maximum that an independent adjudicator could impose would be insufficient punishment for this kind of behaviour. That we submit as the relevance of the police referral. Somebody has sought a governor, so the first governor, to use the terminology I think adopted by the deputy judge, has clearly thought that the internal disciplinary proceedings were insufficiently rigorous to punish this individual sufficiently with 42 days. So, as a result of that, we submit it's clear that by the governor, sorry, the second governor referring to the fact that police have omitted it, and by independent adjudicator Wright referring to the police referral, that, in essence, that could be explained far more clearly, is referring to paragraph 2.23, that they had indicated that the governor, the first governor that made the initial referral, hadn't thought the internal disciplinary procedures had been sufficient.
This is paragraphs 29 and 30 of
That's
the
correct.
judgment, isn't it?
That's correct.
And these, effectively, your third and fourth points fell on stony ground.
Yes. Yes. Hopefully I've taken the court through the authorities, the guidance, and the facts in a great more detail than I did the court below. We submit that this has some air of artificiality because, of course, all of the guidance suggests that an assault on staff would warrant additional days. All the judges before whom this matter came, so District Judge Day and District Judge White, sorry, Independent Adjudicator Day and White, both thought it warranted additional days. Independent Adjudicator White did impose additional days, and then the judge assigned by the senior magistrate to review it upheld that finding of additional days. So in the circumstances, we submit that Hugh Mercer, Queen's Counsel sitting as a deputy judge, was wrong to have concluded that Independent Adjudicator White should have dismissed the matter for want of jurisdiction. The reasons should have perhaps been better or more clearly expressed, but they were sufficient. And that brings me on very, very briefly to ground two. A submission which I think is accepted by my learned friend was that the Deputy Judge didn't consider the provisions of the Senior Courts Act, as were referred to in my skeleton arguments of the proceedings below.
Isn't there a problem? If Mr. Bimler is right that the referral is unlawful unless it gives reasons,
Yes.
then how can Section 31(2)(a) save you?
I think on the basis of were the reasons to have been expressed more clearly, it would have conferred jurisdiction. You know, if the governor, if the matter was remitted to the governor, of course the matter can't be remitted to the
If
governor.
it goes to jurisdiction,
Yes.
as he says,
Yes.
then either the governor's got jurisdiction or he hasn't.
Yes, I suppose that might well be correct. It's somewhat academic because, of course, we couldn't refer the matter back to the governor to provide further and better reasons
No,
in
of course not.
circumstances. But perhaps I've rather been blinkered in my view. I'd always assumed the jurisdictional point was conferred whilst the reasons were brief. They were sufficient to warrant jurisdiction. And in those circumstances, notwithstanding any particular errors in Independent Adjudicator White's decision, the outcome would highly likely not have been any different.
So it works if, in relation to the first issue, the conclusion is insufficiency of reasons.
Yeah.
In other words, jurisdiction but insufficiency of reasons.
Correct. Yes.
Then in that case, you fall back on.
That's correct.
Yes.
Yes. And I'm not going to go through it in great detail. I've referred to one authority, sorry, I've included one authority. I tried to find the most relevant recent one. And it's a page, I'm not going to take the court through it now because the court's very familiar with it. But relevant paragraphs at 36, page 301, 302. This is the case of Gathercole, Suffolk County Council. And paragraph 38 is the key one. Important, the court faced with an application does not shirk the obligation. Provisions designed to ensure that even if there has been some flaw in the decision-making process which might render the decision unlawful, where the other circumstances mean the quashing decision will waste time, money, the decision must not be quashed and the application should instead be rejected. The provision is designed to ensure that judicial review remains flexible and realistic. It's those sort of basic principles that, of course, are well known to this court. But I have to accept if there was no jurisdiction, then I'm in difficulty. It was I guess, the adequacy of the reasons. Hopefully, I've not taken the court too long. Those are my submissions.
No. Thank you very much, Mr. Branderson. Mr. Benmer.
Alice, my lady. I'm grateful to my learned friend for going through the facts and the legal and policy background. So hopefully I won't need to be paining you with that very long, unless there's a specific thing I'll draw to your attention. The headline position is that the respondent invites the court to dismiss the appeal on both grounds. And on ground one, respondent relies on the reasoning and findings of the judge at first instance, but I will respond to some of the further submissions which the appellant has made now. And on ground two, as my learned friend said, I am bound to accept, of course, that Mr. Mercer, Queen's Counsel, as it then was, did not address the Section 31 point. But based on the respondent's notice filed, I would invite your lordship, your ladyship, to decide the Section 31 part of the case yourself and to uphold the order of Mr. Mercer for the additional reasons which I will address the court on when I get to ground of appeal 2. What I should also say, perhaps just by way of introduction, firstly, that there is an excellent application before the court for the additional evidence of Hamza Ladwa to be admitted, and just for the record, there's no objection to that.
Thank you.
It's not been formally mentioned, but there's no objection to that additional evidence. And secondly, I should say there's no point taken on the appeal being academic, and I would adopt the points which my learned friend has made on the relevance. Going to the first ground of appeal then, in my submission, the core of the judgment below is in the conclusion of Mr. Mercer, Queen's Counsel, paragraph 31 of his judgment, which is that the reasons given by the independent adjudicator, considering the governor to have properly considered this threshold for referral, failed to reveal any consideration of so serious threshold by the second court. So the focus there, quite rightly, is on the reasoning given by the independent adjudicator. And in my submission, none of the four factors relied upon by the appellant can succeed in displacing that fundamental conclusion. If I turn to factor one then, relied upon by my learned friend, which, if I can very shortly perhaps summarize it, is the facts spoke for themselves ground. Because the appellant says the referring governor had experience in assessing conduct and prison discipline and prison matters. The system prioritizes expediency, reasons can be short, and the court should be slow to interfere with that. I hope I don't do injustice to my learned friend with that summary. But one key problem in my submission there is that it defends the wrong decision. Because if this was a judicial review of the governor's referral decision, and if the respondent, if Mr. Kane, had sought judicial review of the decision by the governor to refer, and had said he's not given sufficient reasons, etc., then these submissions might be germane. But this is not what this judicial review is about, because the respondent raised this matter as a preliminary point before the independent adjudicator, rather than going to the judicial review of the governor's decision, and invited the independent adjudicator that she had no jurisdiction because there was no proper referral before her. So the submissions which my learned friend made, certainly in his skeleton argument, but perhaps less emphasised today, the submissions which my learned friend made that the administrative court should be slow to interfere with the merits of a seriousness assessment by a prison governor do not go to what this judicial review is about. The administrative court has never interfered with the seriousness assessment by the referring governor. It looked at the decision-making process of the independent adjudicator. And that is
sorry, Mr. Benner, I'd like to write that down.
Could you repeat your last sentence?
Yes. What I say, my lord, is the administrative court did not interfere with the seriousness assessment of the referring governor, because that was not what the judicial review was challenging. What the administrative court did was it reviewed the decision-making of the independent adjudicator, not the decision-maker of the referring governor. And that's quite important if one bears in mind the system, which my learned friend I'm grateful that has taken you through it, and I don't perhaps need to go into it in that detail, but if one looks at the system of who decides on what with these referrals, and that was quite, I think, rightly and correctly emphasised by the judge below, and that's pages 15 to 6, paragraphs 15 to 16, page 70 of the core bundle, which my learned friend has briefly taken your lordship to as well. Because the judge there said, I know that District Judge Wright stated, I'm satisfied the matter is serious enough for referral, but that's not relevant. And the same is true whether or not District Judge Day, Deputy District Judge Day, considered the matter serious enough for referral, or indeed whether District Judge Gouze, who looked at the punishment review, considered the matter serious. Because none of them in the system set up by the rules have the task of assessing seriousness. That task is the task of the governor. And the task of the independent adjudicator afterwards is, I say, to review whether the governor has actually fulfilled that task. It is not for the independent adjudicator or anyone who comes after, be that the Judge Gouze or be that the administrative court, it's not for any of them to step into the governor's shoes and do the seriousness assessment again. So that's what the focus of my submission of this challenge is about. It's about independent adjudicator Wright's role and her determination whether there was a valid referral. And that's quite clear from also the independent adjudicator's hearing record, which is this pro forma or aide memoir which structures the decision making of independent adjudicators. And my learned friend has taken you to it. It says quite clearly that independent adjudicators need to ask themselves, and the reference, if it helps you note, is 189.
What, 189?
189. The right one. Yes, 189 is question F on that pro forma which the court has looked at with my learned friend. The question there is quite clear: is IA satisfied that the governor gave proper consideration whether the charge is so serious? It's not asking whether the independent adjudicator is satisfied that the charge is so serious. It's asking, have you checked that the governor has given proper consideration to it?
We go on to page 191.
Yes.
And the last two sentences on that page.
Yes.
That is the core material, isn't it, that the Deputy Judge was considering when he said what he said at paragraph 31?
Yes, ma'am.
So how does this fit together? The statement that those reasons failed to reveal any consideration of the so serious threshold by the second governor. Isn't that precisely what is being considered by the IA at that point in the record?
Well, my lord, in my submission, the IA does two things at 191. If one looks at the very last paragraph of 191, first, she says, I am satisfied that the matter is serious enough for referral.
Yes, I follow your point about that,
yes,
namely that that's not the test.
That's not the test. It's not her role.
Yeah, I mean, it might be said it's a different way of saying the same thing, but you would say not.
No.
And I understand that.
Yes.
But I'm referring to the second
Yes.
point, which would seem to be relevant to the correct test. And
Yes.
I'm wondering whether you say the district judge, the deputy judge was right to say, failed to reveal any consideration of this question.
Yeah, my lord, I would say that the judge is right, because the judge has gone on to consider these two reasons, and this reason which starts with second, although the governor does not explicitly say so, that's the police referral issue, and that's factor 4 of my learned friends' 4 factors essentially, and the judge, for reasons that I would adopt, has said that the police referral is not a relevant consideration. So the fact that the governor said, I am aware, essentially, that the governor said, if I paraphrase, I am aware that this matter has gone to the police and has come back, that does not demonstrate that he's considered the seriousness of it. So what the deputy judge says...
What, because it's a different governor?
Firstly, because it's a different governor. Secondly, because it's a different test for going to the police or not.
It's very difficult to see how a case could reasonably be viewed as warranting referral to the police, which would not be viewed by any reasonable decision maker as justifying referral to an IA, isn't it?
Well, my lord, I say that this can happen, and these are the reasons. I mean, I was going to address it under the 4th factor, but I can also do it now.
Come to it.
Yes, in essence, I would say the test is different. There are certain things which go to the police without necessarily also meeting the test for an IA referral, which is why the policy itself recognises, and I'll take you to the wording when I get there, but the policy itself recognises that when a matter comes back from the police, the governor then has to make that seriousness assessment. Policy could say, if it comes back from the police, well then you've referred to the IA because you clearly thought it was serious, but that's not what the policy says. The policy says, if it comes back from the police, then you make a seriousness assessment. But I'll take your lordship to the passage in a moment, if I may. But just finishing with that distribution of roles, in my submission, the pathway which is charted on this performa is correct because it reflects, and that's perhaps the O'Brien point here, it reflects that the independent adjudicator only has statutory jurisdiction. She can only hold an inquiry into a charge when there has been a proper and valid referral to her, because her jurisdiction is only established by a Rule 53A referral. And therefore, the independent adjudicator could not say, in my submissions, the facts speak for themselves, because in doing so she would usurp the responsibility of the governor. She has to consider whether the governor has actually exercised his role and assessed seriousness properly.
Well, the question that's being, I think, raised against you is not the facts speak for themselves, but it speaks for itself that the governor considered it was serious enough to refer. That speaks for itself.
Yes.
Which is a different thing. And would you accept, if your argument is right, that it would be right no matter how serious the matter was, or how obvious it was that the governor considered it to be serious enough to refer to the IA?
Well, yes, and I certainly accept, and perhaps this is a convenient moment to make this clear, I certainly accept that in certain circumstances, reasons by the referring governor might be quite short. So, for example, if the governor wrote, in a different case, not this case, if the governor wrote, this prisoner has attacked a member of staff, has injured them badly, member of staff has gone to hospital, therefore this is so serious that I refer to the independent adjudicator. I don't think anyone could quarrel with a referral such as that.
No, but that's changing the scenario. I'm asking you about a situation in which, for example, the piece of wood had hit the governor in the face.
Yes.
And injured her.
Yes.
In those circumstances, your argument is nature of charge would still be an inadequate representation of the governor's assessment of the seriousness of the matter.
Yes, because nature of charge just tells us that it was an assault, but it doesn't tell us anything about it. It doesn't tell us why this assault was seen as serious.
And you're supposed, are you, to stick with the explanation nature of charge without having any regard to surrounding circumstances that are uncontroversial as in this case, for example, recorded on CCTV, your answer is still the same.
My lord, yes. And this goes back to the point that I say the independent adjudicator cannot repeat the seriousness assessment for herself. So it's not the independent adjudicator's role to say, I look at all the circumstances, I consider the CCTV, therefore I think this is serious. That would be the wrong approach. Her approach is, has the governor done that? Now, if the governor had said, this is serious because it's an assault, I've looked at the CCTV, this and this has happened, then probably none of us would be here today, my lord.
But why does the governor have to give any reasons at all?
Because, my lord, because the governor needs to show that he has made determination under Rule 53A. And because Rule 53A does not have, for example, a catalogue of offences which are automatically referred, that could be the case. If Rule 53A had a list of offences and, for example, said all offences, all assaults against staff are automatically referred, then of course nature of the charge would suffice. But Rule 53A says the governor needs to make a determination of seriousness. And in this context, it is quite relevant in my submission that the policy itself says that this needs to be assessed on the merits for each case. And that's, if one looks at the policy, paragraph.
Sorry, sorry to interrupt you. We'll go to the policy in a moment. Let's start with the rule.
Yes.
Suppose there were no policy.
Yes.
Mr. Grandison would be a happier man, but suppose there were no policy and just the rule. It would be enough, wouldn't it, for the governor to write, I am satisfied that the charge is so serious that additional days should be awarded. I therefore refer to an IA.
Well, in my submission, one could still then make a challenge as to whether sufficient and adequate reasons in the Porter sense have been given for that.
So you say that the governor must always give adequate reasons
Yes.
for a referral.
And I accept these reasons. I accept that adequacy of reasons is contextual, and I accept that adequate reasons could be fairly short reasons in a context like this. I'm certainly not saying the governor needs to write 3 long paragraphs in a judicial style determination. But the governor is making a determination, and it is an important determination, because what happens when the governor makes a Rule 53A determination is it opens up this prospect of additional days of detention. Because if the governor under 53A keeps the matter within the prison,
Yes.
there's no prospect of additional days of detention.
Right.
So it is a bit like perhaps a magistrate's court referring to a Crown Court and opening up the bigger...
Well, it is, but I don't think they give reasons, do they? They simply say, we consider that the allegations can be either committal for trial or committal for sentence, but either way, they have to say, we consider that our powers of punishment are inadequate. They don't have to say why, do they?
Well, my lord, I don't have the benefit of being a criminal practitioner, so I do not know, I'm afraid, what level of reasoning they go to. But from a public law perspective, is my submission, even on the basis of the rule itself, but I accept it's a stronger submission on the basis of the policy, but even on the basis of the rule, I would say as a matter of principle, if a governor makes a determination, it is not enough to simply quote the text of the test. And there is some, there is authority in that, which I don't believe I've quoted in the skeleton for this appeal, certainly, that essentially, when reasons are given, it should not simply be a ritualistic rehearsal of the test. So if the governor simply says, I refer this because I'm satisfied the charge is so serious, that does not tell us why the governor thought it was so serious. So my submission
This is quite. This seems to me quite far-reaching, because if you're right, then a governor's decision to refer could always be the subject of a judicial review challenge on the basis that the reasons are inadequate, and that involves an application, as happened in this case, to the administrative court on paper, then an oral renewal, then an application to a member of this court for permission to appeal, and meanwhile the adjudication is potentially stalled.
Yes.
You say, well, that's too bad.
Well, in one sense, I say it's too bad, because I don't think fairness of a procedure can be measured just against whether it would stall the procedure or not. But the second point is, of course, this is why, perhaps, without wishing to speculate, in this case, there was not a judicial review application against the governor's decision. So those representing the respondent did not say, looking at this referral decision, we think it is inadequately reasoned and therefore we're going to trouble the administrative court about it. But they thought it might be more expedient to bring that to the attention of the independent adjudicator and ask the independent adjudicator to consider the absence of a valid referral. That is, of course, a much less troublesome and burdensome procedure, because the independent adjudicator can, as she did, deal with that as a preliminary point without everything else grinding to a halt.
But if the fact that a governor considers, let's assume you're wrong for the moment about the reasons point, or perhaps the governor gave reasons, but the fact that the case is referred to an independent adjudicator doesn't mean the independent adjudicator has to take the same view of seriousness. The district judge might think, why is this trivial case being referred to me? I find the case proved, but I decline to make any award of additional days. Doesn't mean to say that the referral was unlawful.
Well, of course, an independent adjudicator might be able to do that, but in my submission, the point, because it goes to the jurisdiction, because it goes to the fact that the independent adjudicator can only enter into the process of hearing the charge and then making considerations on sentence, if she is satisfied that she has jurisdiction. She only has jurisdiction by virtue of a 53A referral.
Yes.
Therefore, she needs to consider that, and she needs to especially consider it when it is brought to her attention as a preliminary objection. So to perhaps preempt the question that might or might not trouble the court, I'm not saying that in every case the independent adjudicator needs to open a lengthy procedure of reviewing the validity of a referral. It may be that in the majority of cases, the validity of referral is actually not in dispute between the parties. But here, this matter was clearly raised as a preliminary point. And therefore it was incumbent on her to deal with that point and to deal with it properly and to give proper reasons for her decision. And again, this comes back to the point I'm at danger of making once too often, that the judicial review is focused on her reasoning for dismissing the preliminary objection rather than the governor's reasons.
Could you help us about this? I appreciate that in relation to a matter of jurisdiction, a person is entirely entitled to take a point if they're facing some jeopardy in a place they shouldn't be. But that apart, that being a technical jurisdictional argument, is there any substance behind this at all? Or is it no more, no more than what you would say is a good technical jurisdictional argument which found favour with the High Court? There's no substance in this, or dare I say it, merit at all, is there?
Well, my lord, perhaps the question is what one defines as substance, but the merit of this, in my submission, is that because this was not, and I don't want to lapse into assessing seriousness for myself now, or inviting this court to assess seriousness for itself, but because this was a case where there was no injury, no physical injury caused, in my submission, it was a case where the governor had to properly look at whether this actually merits a referral and had to give reasons which went beyond simply nature of the offence. And therefore, the independent adjudicator needed to properly look at whether the governor had actually considered the seriousness. So this is why I say there is merit in it. There was a jurisdictional point. There was a point as to has the governor actually given thought to this. That is the merit. And it may seem a technicality, and I acknowledge that the facts of this case are perhaps not particularly attractive, and the facts of what the claim that the respondent was in the end found to have done are not particularly attractive, although of course if there was no jurisdiction that finding by itself falls away. But I do say that the jurisdictional point is an important one here.
Thank you.
Yes.
My lord, I'm grateful. The other point which I would make is that in my submission, and this is still on the first factor, I should say, when deciding, which was her role, when deciding whether the governor had properly addressed his mind to the referral threshold, had properly made a Rule 53A determination, the independent adjudicator should take into account the relevant prison service instruction. And that's not because I say the PSI binds the independent adjudicator. I certainly accept it cannot bind the independent adjudicator as an independent judge. But because the PSI binds the governor, as my learned friend has accepted, on lumbar principles, on principles that it's issued by virtue of the appellant's general superintendence of prisons.
Yes.
And in this case, of course, the IA's attention was specifically drawn to that PSI when the validity of the governor's referral was challenged. And your lordships and your ladyship will have that at page 191.
Yes.
191 in the narrative record again, looking at that second paragraph. It says preliminary point was made, and it's in shorthand form, but it says preliminary point was made essentially about the procedure followed when the matter was referred to me. Does the charge meet the seriousness criteria? Then she states what the governor had noted in the record, namely nature and police returning it. And then there is a reference, although it's a slightly opaque one, to the PSI. And I say that this was a reference to the PSI as binding and as guiding the governor as to how they exercise their referral power. And again, my learned friend has taken the court to it, but I would emphasize, as my learned friend predicted I would, that the guidance does say that governors need to state reasons. And it says that at 2.31. And at 2.32, it gives an interpretation, and that's the appellant's interpretation of the seriousness. Yes? So instead of saying, in essence, Rule 53A speaks for itself, the appellant has decided to interpret or further refine the seriousness test at page 232, and paragraph 232, and I apologize, I should have given the page reference. So that's starting at page 42, supplementary. 231 it says that reasons should be given, and it specifically notes the seriousness of the offence alone may not be sufficient. That's the appellant's view in policy, not simply my submission. The appellant's view in policy was give reasons, do not simply say seriousness of the offence. In 232, it
It's
explains.
not quite what it says, is it?
Well, my lord,
It says, as quoting, quote, seriousness of the offence, unquote, alone, may not be sufficient in all cases.
Yes, which is the explanation for why it says in the first half of the passage should state their reasons, and that goes back to whether reasons are required or not when the governor makes a determination. So the appellant's position in policy is the adjudicating governor should state reasons for why they refer, and then they say, background to this, well, seriousness of the offence may not be sufficient in all cases, therefore err on the side of giving reasons. And
That's a sort of back-covering exercise, really, isn't it? If it's not sufficient in all cases,
Yes.
it's probably sufficient in most cases, one might think.
That might be, depends what view. It's not spelled out there, but it says you should give reasons, in essence, because you may be in peril if you do not give reasons, as it says further down. And then at 2.332, as I said, it explains the seriousness test and says what governors actually have to consider. But then there's 2 points I would highlight there. Firstly, that governors should bear in mind that IAs are an expensive resource, as is the legal aid that prisoners may claim for representation at IA hearings. And then it says each case will be assessed on its merits. So in my submission, that's a strong steer in the policy to say you must actually consider that seriousness test. You should not simply say, I automatically refer this because it is an assault, which in essence is what I say the referring governor has done here. You should assess each case on the merits and think about the fact that IAs are an expensive resource. And then it gives some examples, but again, it doesn't say all assaults should be referred. It says serious assaults should be referred. Then it gives some examples of serious injuries, and that's certainly not this case. And then it gives different other factors. And there is quite an important distinction there, because my learned friend has taken you to the third bullet point there. Victims' role within the establishment, e.g. staff, their vulnerability and the location of the incident will also be factors. But will also be factors cannot mean assaults on staff qualify for automatic referral. So there's this distinction here in the policy, in my submission, about those assaults leading to serious injury, which the policymaker says you shall refer always. And then these 3 bullet points where it says, well, if it's not a serious assault, then these are factors which you can/should take into account. But there is no automatism anymore. And I certainly don't dispute that these are cogent factors. And indeed, if the referring governor had referred to any of these factors, even briefly, and even in relatively abbreviated format, then again, I doubt this judicial review would have ever been brought. But he did not. The governor did not show in any way that he's considered, PSI has considered this guidance as to what should be referred and what not. The governor did not show at all what factors he has taken into account. And then again, the last point on this is, of course, 2.33, over leave, page 43, essentially cautioning governors that if the independent adjudicator considers the referral to have been unlawful, it may well be dismissed. And then it helpfully spells out that in the appellant's view, an unlawful referral is one where either the prison rules or youth offender institution rules have not been followed, or where the PSI has not been, i.e. a case which should not have been referred in the first place if the guidelines in the PSI have been followed correctly. And then it gives an example, a case simply disobeying an officer with no other aggravating features. So that again points to the appellant's view in policy that governors should not fall into the trap of referring cases due to the nature of the charge, but should consider what factors make this case so serious and what factors make this case referable. And again, in my basic submission before this court, as it was in the court below, is that the independent adjudicator can only be satisfied that the governor has properly carried out his or her task and has properly approached the Rule 53A determination according to the rules and according to the PSI, if there is actually evidence before her that the governor has done that. That is, if there is evidence before the independent adjudicator that the governor has properly assessed seriousness and has evaluated the seriousness of the case on its individual merits, rather than giving generic reasoning, such as due to the nature of this charge. And again, for the avoidance of doubt, I accept such reasons do not need to be long, they do not need to be sophisticated, they do not need to be to the standard of a court or a legally trained person, but they need to be there in some appreciable form.
Was the governor entitled to view the facts or the allegations as set out on page 163 of the bundle as a whole?
Well, my lord, I would say that the way Rule 53A deals with it is that the governor needs to consider for each charge individual, whether it meets the seriousness threshold, and if he refers one charge, then all the other three charges go with it. So there is then, in a sense, no need to look at the other charges individually, but what I anticipate would happen in practice is that the governor looks at the seriousness of what could be called the lead charge, or the most severe charge, and makes a determination of the seriousness of that. And then the other charges are sent with it, as it were, because that's what Rule 53A provides.
Are you submitting that obviousness has no part to play at any stage in the process?
Yes, I would submit that obviousness has no role to play. Because obviousness is the same as saying simply nature of the charge. So there may be, in certain cases, it may, as I said, be sufficient to be quite short. And it may be sufficient to say, let's say, this was an assault on a senior staff member and she could have suffered significant injury if the piece of wood had hit her. And perhaps the governor would have even
Right, so all of that is obvious. But it needs to be stated, you say. And if it isn't stated, the fact that it's obvious is irrelevant.
Doesn't help, because what I say is one needs to see what the governor has actually applied his or her mind to. So there could be different reasons why the governor referred. It could be that the governor was thinking about the antecedents of the prisoner. It could be that the governor was thinking about who
Exactly.
the
That would, I think we've established already, that had the governor been hit by the wood in the face and had to have stitches in her face,
yes,
your argument would equally hold.
It would equally hold. It could be very short reasons, but it needs reason, because one needs to understand, and not only the independent adjudicator, but also the prisoner needs to understand why was this referral made. What was the factor which was on the governor's mind when deciding to refer. And we may think in hindsight that this is obvious, but because there are different factors which play on seriousness, in my submission, the governor needs to state which of these factors played on his or her mind. And that can be as short as saying because of the victim, or because of the role of the victim, or because of the potential for serious harm if it had actually hit her. It could be any of this, but it needs to be clear in my submission what factors, what of the obvious factors in the circumstances of this offence were the ones which led the governor to make the referral.
And you say it's not enough for the decision maker to trot out the words of the rule. I think you were going to refer to a case which said so, but if you did, I'm afraid I didn't note it down.
I said I wouldn't because I said I did not have it in the skeleton for this case.
Okay.
I can try to find it over the lunch break.
Well, it would be odd if. Let's take a clearly serious case that suppose he had thrown the wood at the governor. It had hit her and caused some injury, not grievous bodily harm, but some injury. The matter is referred to the police, who, for whatever reason, say we're not interested. Would it be insufficient for the governor on those facts to say this was an assault which was so serious that I consider that additional days may be awarded. I have therefore referred it.
Yeah, in my submission that would be insufficient because it still doesn't tell why it was considered so serious.
Right.
So that's my submission, that the obviousness does not assist. The governor cannot simply say it's obvious.
Yes.
What
you're asking for is more than a determination. What is required by the rules is a determination.
Yes.
You say that the PSI means that you're entitled to an analysis.
Well,
it's not. The rules is not enough. Telling the story is not enough. The passage that my lord's just referred to. The rules are not enough. The facts are not enough. You say you need an analysis, however short, of why it's serious.
Yes. Yes. Right. And that might be so. Again, if in that box giving reasons for referral, some kind of narrative had been put, then that might stand as the analysis. So if the governor in the reasons for referral said this was an attack on a governor who could have been injured badly if she'd not ducked away, therefore this is serious and warrants referral, that's enough analysis. So I'm not saying there needs to be a structured legalistic analysis of different factors, but it needs to be clear what the governor actually had in mind when considering seriousness, other than the nature of the charge itself, which is assault.
All right.
And in this case, going back to what I say is the core of the judicial review, which is the independent adjudicator's reasoning, not the governor's reasoning.
Yes.
The independent adjudicator has ostensibly given two reasons. Well, first she said, as we heard before, first she said, I am satisfied that it's serious, but that's just the wrong approach because it's not her role. And then she's given ostensibly two reasons for why she was satisfied. And the deputy judge has taken some time to analyse these reasons, paragraphs 15 to 30 of his judgment, to say that these reasons were misconceived and could not justify the independent adjudicator's conclusions. And I would respectfully adopt those reasons given by the deputy judge. And it's interesting that in these proceedings, the appellant does not appear anymore to defend the first of the reasons given by independent adjudicator, right? So this reason which was about COVID-19 regulations. Appellant does not seem to defend that part of the reasoning anymore. He only defends the reliance on the police referral, which had come back, and that's of course the appellant's fourth limb. And I'll address that in a moment. But these are the reasons which the deputy judge reviewed. Can I just look briefly at a couple of the authorities which my learned friend relies on for this first of his four factors? And the one he particularly relied on today was the Vasey case in the Court of Appeal Criminal Division. And he says that Vasey is authority for the proposition that when a governor refers an incident to the police, there is no need for lengthy or detailed reasons. But I would say that there's three important distinctions with Vasey in the present case. Because firstly, referrals by governors to the police are not in any way governed or constrained by the prison rules or by any other legislation. There's no statutory rule about governors making a certain determination or applying a certain test before they refer something to the police. And that's, of course, something which the divisional court, which my lady was part of, held in O'Brien, paragraph 74 of O'Brien, that it's an implied power of governors and that there is guidance to them on how to exercise that power, but it's not a formal procedure regulated by statute in the way that Rule 53A determinations are. And the second point is that the same jurisdiction issue doesn't arise because the police does not require a formal referral to investigate anything. Any referral to them of a matter is not constitutive of the police's jurisdiction or indeed of the CPS jurisdiction afterwards to prosecute it. The police could equally well act if there was, for example, no referral by a governor, but if there was a complaint by a victim about the alleged offending in the prison, or if the police came to know about the incident in whatever other way, they would not be preempted from acting. Whereas the independent adjudicator, of course, can only act if there is a valid Rule 53A determination. So therefore, in my submission, it's not surprising that the criminal division in Vasey decided that the informal and non-statutory decision to make a referral to the police does not need detailed reasoning. But in my submission, that does not translate to Rule 53A determinations. Because in Rule 53A determinations, there is a particular statutory threshold, and there is a particular procedure of determination. And the last point, perhaps, is that in Vasey, as my lord pointed out to my learned friend, in Vasey the court actually took account of ex post facto evidence from the prison governor as to why the case was referred to the police. And in this case, we don't have any evidence from the governor, any ex post facto evidence. We have a statement from district judge Wright, but there is nothing from the governor who referred by way of additional evidence. So that's another difference to Vasey. Can I just very briefly address two other cases which my learned friend referred to in his skeleton, but did not particularly draw on this morning, so that's why I'll keep it short. But these are the cases of Bannatyne and Bate, and dealt with adequacy of reasons given by independent adjudicators. So Bannatyne was a challenge to an independent adjudicator finding that a certain charge was proven in the light of conflicting witness evidence. And it was a charge to the adequacy of the reasons given for that finding. And if your lordships are interested in looking at the case, it's tab 3, but I don't propose to take you through it.
Well, I think Mr. Grandison must be right to say, mustn't he, that reasons for convicting somebody of something have to be a lot better than reasons for referral. Even supposing you're right, I don't think anyone would suggest that what the governor put on the form would have been enough to sustain a conviction.
Yes, absolutely, my lord. But my point about, and I don't argue against that at all. I think my point about Bannatyne was simply that because my learned friend has relied on it to say that the court should not expect a high standard of reasons from independent adjudicators. And of course, here the challenge, in this case, the challenge is to the reasoning of the independent adjudicator. But Bannatyne, in Bannatyne, what Mr. Justice Sullivan said was simply that where an independent adjudicator had heard from different witnesses and decided to prefer the account of one set of witnesses, which were prison officers in that case, over the accounts of other witnesses, which were prisoners in that case, the independent adjudicator does not need to give very detailed reasons for that. It's enough for the independent adjudicator to say, I found these accounts more credible than the other account, because he has the advantage of being the trial judge, so to speak. And that's certainly uncontroversial, but that was a case about an independent adjudicator making findings of fact. It's not about an independent adjudicator determining a point of law, which is, has she got jurisdiction founded on a valid referral? Because that point does not depend on oral evidence or on a credibility assessment. But there must be, in my submission, a cogent basis for the independent adjudicator to conclude that the governor's referral was valid. And again, Bates, in my submission, which your ladyship had at tab 7, is a similar case. It was again challenged to a finding of guilt, and the judge there, Stephen Mayles, Queen's Counsel as he then was, now Lord Justice Mayles, held that the court should be slow to interfere with an independent adjudicator's evaluation of evidence when there was material upon which the independent adjudicator was entitled to decide that the charge was proven. But again, that's about the decision on a question of fact and evidence, not law. And the respondent's very point in these proceedings has always been that the independent adjudicator has not shown that there was material before her upon which she was entitled to find the referral to be valid. So in my submission, Wasey and Bannatyne and Bates do not assist with this question of what reasons an independent adjudicator needs to give for finding that there was a valid referral and that her jurisdiction has been properly established. Can I go to the other factors relied upon by my learned friend then? And I'll be shorter on them than on factor 1, because factor 1 was perhaps really the one which established the basis. Factor 2, my learned friend has said that there is very limited scope of the independent adjudicator's power to review a referral. And there is some overlap there with factor 1, I think, because I've addressed you on what the respective roles and limits of the roles of the governor and independent adjudicator is. So I would certainly agree that the independent adjudicator has a limited power to review in the sense that she could not substitute her own assessment of seriousness for that of the governor. I think so far there's no dispute between the parties. So it would certainly be wrong for an independent adjudicator to say, I've reviewed this, I'm not satisfied that it's serious enough, therefore I dismiss it. That would be wrong, because that's not her role. My learned friend has said in his skeleton, paragraph 40 of his skeleton, that a jurisdiction challenge is not, quote, an opportunity to argue the finer points of what would amount to mitigation of the sentence. And I agree with that. That is correct. But that's not what the respondent's solicitor did in this case when he brought the preliminary objection. the respondent solicitor did not try to make an early plea in mitigation, as it were, but the respondent solicitor expressly queried whether the correct procedure had been followed in referring the case to the independent adjudicator. And he drew attention to the test, and he said that the independent adjudicator did not have jurisdiction because the correct procedure had not been followed. So the respondent at no point asked the independent adjudicator to make her own independent assessment of seriousness, although unfortunately that's then what she proceeded to do with the first sentence of her reasons, nor made any mitigation points. He simply pointed to the defect in the referral. So to the extent that there is limited scope of the independent adjudicator's power to review a referral, I say this preliminary objection very much fell within that limited scope. And my learned friend also said, again in his paragraph 40, the skeleton, that the threshold for finding a referral to be unlawful, so the threshold for an independent adjudicator to find a referral to be unlawful is, quote, necessarily a high one. But there's no authority given for that. And I would not accept that there is anything necessary or inherent in there being a high threshold for such a finding. Because the independent adjudicator is determining a core issue here. Does she have jurisdiction to proceed or not? Has there been a lawful referral establishing her jurisdiction? And that's a binary decision. There is no logical reason in my submission why there should be a high threshold for her saying, no, there's not been a valid referral. Because the independent adjudicator is not asked to conduct something like an irrationality review of the governor's referral decision, where one might think there should be a high threshold. That's something that Mr. Mercer KC correctly identified. It's not that the independent adjudicator is asked to look again into the factual foundations and make up her mind whether the governor had rationally referred the case. But it's a question of the independent adjudicator looking at whether the governor had actually undertaken his role properly and had actually assessed seriousness on its merits, or had omitted to do so. And lastly, paragraph 40 of the skeleton, dealing with that second factor, my learned friend also said the focus of Mr. Mercer, King's counsel below, Queen's counsel as he was, should have been on the governor's decision to refer. But in my submission, that's wrong as a matter of principle, because the referral decision was not the impugned decision. So Mr. Mercer's focus was correctly on the decision of the independent adjudicator. Mr. Mercer's focus was correctly on analysing whether the reasons given by the independent adjudicator were lawful and proper reasons, or whether the independent adjudicator fell into error of law. So that the judge did not have the wrong focus there, properly looked at the reasons and evidence before her, in her determination. And that then really draws into factor 3, which is again about what lens the judge applied. As my learned friend says, that the judge erroneously applied a prism of criminal law, and especially attacks Mr. Mercer's reasoning at paragraph 30. And in my submission, that's not what the judge did. And at this point, it may be convenient to turn up the reasoning of the judge again. If one looks, paragraph 30 is core bundle 73. And it's necessary to look at the context of paragraph 30 of the judge's reasoning, which is the one being attacked here. Because just before paragraph 30, the judge analysed whether the independent adjudicator could lawfully rely on the fact that the referring governor had considered that the matter had been referred to the police previously. That's paragraphs 26 onwards where Mr. Mercer looked at that. And his finding, paragraphs 28 to 29, and we'll come to that in the fourth factor, but his finding, 28 to 29, was the threshold for referrals to police was different from the threshold for referrals to an independent adjudicator. And the decision to refer to the police does not imply by itself that the threshold for an independent adjudicator referral was met. So that's what the judge considered immediately before coming to paragraph 30. And then, at paragraph 30, the deputy judge turned to the governor's comment on the nature of the offence. So he says the reference by Deputy Judge Wright to the matter being serious enough may be capable of being interpreted as a reference to the nature of the offence, on which the second governor relied. So the second governor's other reason besides police referral. And in paragraph 30, Deputy Judge considered whether that comment on nature of the offence showed sufficient consideration of the referral threshold by the second governor, which means that independent adjudicator right could be satisfied that the governor actually had turned his mind to the seriousness.
What deduction could one make from the fact that the governor referred the matter to the police?
What deduction could one make?
Yes, what deduction
Well,
or inference might one draw from that?
Well, the only inference, as I'll say in a minute, the only inference that I say one can make is that another governor, the first governor, had considered the matter to meet the policy threshold or policy test for police referral. That's the only inference. It doesn't tell us anything about the independent adjudicator referral threshold. It doesn't tell us anything about Rule 53A. The only inference is, firstly, well, there's two inferences really. Firstly, a governor has looked at that and said it meets the criteria for referring this to the police, which are policy criteria. And the other inference is the police has decided we're not interested. One doesn't know why. We don't have any evidence on why the police has sent it back, other than the fact that they've sent it back very quickly. So it's not a case where the police made...
So your submission is that the independent adjudicator was obliged to regard that as being a completely neutral element of the facts of this case.
Yes, it doesn't help with assessing seriousness because it's a different and we will.
No, it doesn't help assessing the governor's view of seriousness.
Yes. So, just returning to what Mr. Mercer, Queen's Counsel, looked at in paragraph 30, because Mr. Mercer's finding was that the independent adjudicator could not lawfully rely on the governor's comment about the nature of the offence because there is no guidance or rule saying that all staff assaults are to be referred to the independent adjudicator, or indeed that all assaults should be referred to the independent adjudicator. And that's how Mr. Mercer went on to say assaults are many and various, as are the circumstances in which they occur. So the deputy judge found that assaults in the custodial context can differ from one another, which is why there is no automaticity of assaults all being referred to an independent adjudicator. And he's then given some examples of custody-specific circumstances, which could be factors in a seriousness evaluation. So he's given a couple of examples: conditions of detention, applicable visits regime, nature of the claim's relation with the addressee. And one might agree or disagree about these factors, and one might think that other factors also go into seriousness. But what I say, what the judge has not done, is somehow fall into the error of applying a criminal law prism. Because the considerations which he refers to there are clearly custodial considerations and are clearly considerations which would apply or potentially apply to determination of seriousness of a charge in a custodial context. It wouldn't apply outside of a custodial context. So I'm afraid I don't understand really the submission that there was a prison of criminal law being applied. There was no, if the deputy judge had started looking at criminal case law about assaults or sentencing guidelines for assaults, then I would understand it. But he didn't. He just said, and I say correctly said, that the question of seriousness of an assault is a life question in the custodial context. Because in the custodial context, there is a range of severity of assaults. And he's given some examples of what factors might arise. And therefore, his conclusion was an independent adjudicator must see more evidence of consideration of seriousness from a referring governor than simply saying nature of the charge. So there was no error in the deputy judge's reasoning either there in my submission. I'm about to go on to the fourth factor, which is the police factor, but I'm also mindful of the time. Would your lordships wish me to stop here or carry on?
How long do you think you have to go? I know it depends on how often we interrupt you, but on present estimate.
Yes. Well, I'd say that the police referral issue is perhaps an important one because one needs to look at the different tests. So I'd say perhaps another 10 minutes or 15 minutes on police referral maximum. And then I do have a few things to say about ground 2 in section 31.
Right, thank you. 2 o'clock.
Right.